All right, I think we're going to go ahead and get started. Feel free to eat, get up, move about if you need to. I am Melissa Davey. I am one of the Chapter 13 trustees here in the Northern District of Georgia. I handle cases in the Atlanta and Noonan Division and cases assigned to Judge Richie Craig and Judge Bezier. Thank you all for coming out today. We are here representing our local Bench and Bar Committee. If you don't know about the Bench and Bar Committee, it was established in 2013 in our court, and we have members that are appointed from practitioners in the district, appointed every year, and there is a link on the court's website. But basically, we facilitate communication between the bench and the bar about our local practice. So it could be local rules or general orders or just procedural issues that we need to discuss. So to the extent that you have any of those issues, please, there's an email address. You can reach out to us and we will discuss them. So thank you all. I'd like to thank our co-sponsors for the event, the Atlanta Bar Bankruptcy Section and the W. Homer Drake Georgia Bankruptcy American Inn of Court. So thanks for our Chick-fil-A. We appreciate it. Welcome to our judges. Thank you for your support and for attending today. And to Benia Allen, our clerk of court, and her staff who have helped us set up this room and do all of this today. And to the members of the Bench and Bar Committee that helped plan, and also to the IT team for setting this up. So today we're going to talk about the difficult debtor. And I know you're all thinking they're all difficult, right? But not those debtors necessarily, the really, really special ones. We're going to talk about just the sort of common life issues that come up in cases. Life is messy and we tend to see all of the mess in bankruptcy. And so we're going to talk about disabled, incompetent, incapacitated debtors, debtors that die during bankruptcy, debtors that get divorced. That comes up all the time. Debtors that disappear. And then also just the general disagreeable debtors that cause you problems. And so my co-panelist today, to my right, the Honorable Lisa Richie Craig. I think everybody knows her. She has been on the bench since 2016 and handles cases in the Atlanta and the Noonan Division. She's a double bear from Mercer, so she represents us well and reminds us of Judge Drake because of that. And then to my left is David Johnson. David is the managing partner at Hurt & Johnson, mostly practices in Rome, and he does consumer bankruptcy, Chapter 7, 12s, 13s, and then probably some sub 5s too, yes?
Haven't done one yet, but sometimes I send those to
All right. And then to his left, we have Leon Jones, who is a managing partner at Jones & Walden here in Atlanta. Leon is a man of all trades. He does a lot of sub 5s. He's a sub 5 trustee, but also does debtor work in 7s, 11s, 13s. I think does creditor work, occasional 12s, and some. Yep. So let's get started. All right. So I think I have the clicker. All right, so we're gonna deal with a hypo today. It's a global hypothetical, which I will read, but you can also follow along on the screen. All right, we have John and Mary Smith, a married couple in their late 50s. They have significant secured and unsecured debts, though their primary residence is solely owned by John and is currently facing foreclosure. Mary is the main income provider, and John has had to stop working because he's had multiple strokes that have resulted in cognitive impairments impacting his memory, communication, and decision-making abilities. The majority of their debts are joint, including their vehicle loans, credit cards, and medical expenses mainly associated with John. Mary believes that filing a joint Chapter 13 bankruptcy is necessary to save their home and restructure their debts. Mary has come in to consult with a bankruptcy attorney, we'll say David, and would like to pursue a joint Chapter 13 filing. However, John did not participate in the consultation. He's incapacitated and can't come to the office. So, Mary reports that John is in the hospital after his most recent stroke, and medical professionals have determined that he lacks the capacity to make legal decisions. Mary has managed all of the household financial matters for several years. 6 weeks ago, Mary obtained a general durable power of attorney appointing her as John's agent. It's notarized, but the document does not explicitly grant authority for bankruptcy or litigation matters and is not supported by any medical evaluation. Is it permissible for debtors' counsel to file a joint Chapter 13 bankruptcy petition for Mary and John without directly consulting John? So, David, how would you handle this situation, and what do you think about this power of attorney?
Well, first of all, I want to say thank you for having me. Like you said, I'm mostly up in Rome. I don't make it to Atlanta that often. And I noticed that the security here is a lot more intense than what we get up in Rome. And I actually think last time was that mediation with you, Leon. So again, happy to be here. And I wanted to ask the audience, have you all had situations like this for the debtors' attorneys out there? You get someone calling and they want to file a bankruptcy on behalf of a family member. Usually it's an ailing parent. Maybe they have a power of attorney. I don't see many. They're rare. But maybe once a year we probably get a call, someone coming in with this type of situation. So it's important to know what you can and can't do, what the rules are. Regarding the power of attorney, typically I find that people have downloaded a generic one off the internet. It may be vague. And when you're discussing it with them, this is kind of like the hypo. I'll say, well, when did Dad first start having trouble? Well, 2 years ago, he had a stroke. He hasn't been the same since, and I've been doing my best to help him. Then you look at the power of attorney, and it was signed 2 weeks ago. Well, obviously, that's a problem. It's probably not effective. And it's important to know, if you don't, that in 2017, Georgia passed and adopted the Uniform Power of Attorney Act. The main takeaway, I think, for us is that there's a form they want you to use, and the form's important because if you use it elsewhere in the code, you can compel institutions, banks, entities to deal with you as if you are that person. And I'll say, if the form's very easy to use, it's embedded in the code, and if you go looking for this, go to the Georgia.gov.
We actually handed them out today.
Oh,
that came
there are
from
some
the
out
form.
there. Georgia.gov, under the aging site there, in addition to the form, are the instructions with it?
No,
we
Just
didn't.
the form?
It's
Yeah.
about 40 pages.
The
so
instructions
Yeah,
are
I was
40
gonna say,
pages.
the form is pretty easy. It's very much check the box. But the instructions, it's about 20 pages, but they're detailed and easy to follow along. So if you have clients or former clients that are calling you and asking if you do this, I wouldn't be afraid. I'd say, sure, bring them in, help them out, do the form, and you can charge them for your time.
So, David, I have a question. Can you add something to the form? Because I noticed there's no bankruptcy checkbox.
No, there is no bankruptcy checkbox. Now, at the end, towards the end of the form, you'll see there's kind of a add what you want special section. There's also an opt-out section for really important things. So, follow the instructions. And if you wanted to go the bankruptcy as permissible route, I think at the end maybe you try to add it in there. But again, when these people come in, I never see anything like that. It's something generic.
There is a claims and litigation section, and also a states, trust, other beneficial interest, and a fiduciary section. So
perhaps it falls within the glue that would stick that together. But the reason it kind of doesn't matter, I'd say the power of attorney, it's not a deal breaker, it's not a deal maker, is we have a rule, and that rule is 1004.1. And it governs the filing of a bankruptcy case on behalf of an infant, which means a minor, or an incompetent person. I don't know why a minor would need to file a bankruptcy. I know I've never done it. And of course, the hypo here alludes to someone who may be incompetent. The word incompetent is not defined in the bankruptcy code. The word we use in state law is capacity or lacks capacity. I did find it's worth noting that in Code Section 109H4 for waiving the credit counseling requirement, that can be done for someone due to disability or incapacity. So you do have that word capacity elsewhere in the bankruptcy code. Now, turning back to the rule, if you have someone that may be incompetent, the rule says that if there's a guardian or conservator already out there, only that person can file the bankruptcy case. Personally, I've never had a guardian or conservator come in. I could see it happening though. Maybe someone who had significant assets and they have a problem and they're making terrible decisions. The family comes in and gets a conservator appointed. They take a look at it and say, you know what, the best solution here is going to be a bankruptcy filing. If there isn't a guardian or a conservator out there, the fallback option is through a next friend or a guardian ad litem. I also haven't had a guardian ad litem come in. Maybe there's some other litigation out there. I could see a pro se debtor filing some state court action to stop a foreclosure, or maybe there's a divorce and one of the spouses has a stroke and that divorce court appoints a guardian ad litem. So maybe that could be a situation when it happens. But most of the time, you're going to be using the next friend.
Okay. So, Judge, from your perspective, when a debtor's competency is clearly in question at intake, what do you expect counsel to do before filing the petition?
So I would expect that, David, you would have had a conversation with the person that's in your office, that you would assess sort of their veracity, their knowledge of the situation, so that you, obviously you're not a detective, but use some detective skills to figure out, do you think these people are honest? Do you think there's some ill will going on? What's happening behind the scenes, so that you know that it's because the court's going to have to make a decision whether or not this person can be appointed as a guardian ad litem at some point. And we can get to it, but we may not need medical testimony to get there. But what we need is the sort of the goodwill that this person brings, and the care and the consideration and the knowledge of the assets and the situation that the debtor is going to be in. So we need sort of a full picture approach. So any information that you can elicit beforehand to work that into the affidavits and or argument is going to be very, very helpful.
Do you think that, does counsel have to independently assess competency, or can you rely on the representations of the family member of the spouse? I mean, do you have to meet with the client? Do you have to go see them? How do you even know any of this, I guess is my question.
Well, I would say this is definitely a situation that is, you want to trust Mary, but this is a trust but verify. You need to vet Mary and make sure that, maybe they haven't been married that long. Or maybe you get other yellow flags, red flags that you're worried about what's going on here.
How many times has Mary been married, and how many husbands have been incapacitated? It could happen.
It could.
The Black Widow Mary.
And I want to touch on the next friend. What is that? It's a common law concept that goes, way back. But the Supreme Court has said, and it seems to come up in habeas corpus cases, but a next friend needs to show three things. First, that why they're needed. Why is the real party unable to prosecute the case on their own? We kind of already have that here if there's someone who's incompetent, right? Then number two is that they have the real party's best interests at heart, okay? And then finally, there should be some sort of close family relationship. Spouse would qualify, I would think, a family member. But if you have those things, then you can do the next friend. Now, here to finally answer the question, and I'll kind of break it into pieces. Can Mary file a joint case on her own behalf and for John? I think the answer is yes. But the trickier question is, can you do this without ever meeting with John? Maybe, but I wouldn't. I think that's very dangerous. I can tell you I've gotten in the car and driven to the hospital or to the home to meet with somebody if I'm being told, that they can't come in, they can't talk to you. So I wouldn't do it. An exception might be an emergency. I know Leon's going to talk more later about the Georgia bar rules that can come in, but 1.14, if you've got a client with diminished capacity, in the comments to that rule, if there's an emergency, you can take action to preserve the status quo if you've talked to them or somebody who has their in good faith is trying to help them out. But then once you do, you have to then go try to establish an attorney-client relationship. So maybe file the petition. I've had people come in an hour before foreclosure. They didn't have diminished capacities, thankfully, but you file the case and then get the stay, preserve the status quo, and then go talk to them. So I think you could, but I wouldn't do it without talking to John.
And I have two more questions. One is, what documents should be included with the voluntary petition in the case? And then second, if Mary's filing for John, how does Mary sign the petition?
You might want to take a look at what your bankruptcy software lets you do. I looked at mine, and I'm unable to tinker with how that electronic signature is displayed there. So I think if I would do it, it would be to insert some sort of document maybe after the petition or at the end of everything that says all the signatures should be construed as, Mary signing on behalf of John as next friend. But anything you put in the petition, I don't think the judge or the clerk is going to notice it. You need to have something else on the docket.
Right. So remember, the judge isn't going to look at a petition unless it's coming up for a hearing or it comes up on some pending report that we might run, which don't count on that. So if there's a pending motion, we will look and review. But if you file something and attach it to a petition, in the Chapter 13 trustee is probably going to be the first one that realizes that, and then they will question the debtor, perhaps at the meeting of creditors, and then perhaps file a motion, or a creditor may notice. But if you've got something that you feel that's important to attach to the petition, and you want it to be seen, you might want to consider filing a motion if you need direction. So like in this case, you might file a motion to appoint a guardian ad litem, because remember the rule says that the next friend or guardian ad litem may file the petition, and the court must appoint a guardian ad litem or issue any other order needed to protect the interests of the debtor. So that's going to be the next thing. So maybe that you file it simultaneously.
Right, and Leon mentioned this, that you do your first day motions in Chapter 11s. They're a big thing. I would think you do that in a Chapter 13 here. Right after the petition, file a motion to appoint, presumably Mary, as the guardian ad litem, and that's what'll get it in front of the judge.
Correct, because otherwise, as a Chapter 13 trustee, I am not going to conduct a meeting of creditors where I only have one debtor on a joint petition. And I'm not going to be comfortable with Mary testifying unless I have a court order directing that Mary's the appropriate person to testify. And I think at that point, we've got to get a guardian in place, and it could be Mary. But so let's talk about that. One thing I wanted to say before we move on is, in terms of intake, this is not a time where virtual intake is going to work. I really, really don't think that you should be talking to Mary on the phone or doing a Zoom consultation with her. And people are laughing at this, but these are the sorts of things that happen. You've got to have them in your office. And really, if you can, figure out what's going on with John, if you can see him face to face. Right. Everybody agree with me on that? I think that's very dangerous. Yes, Judge.
I had one of these recently, and I've been here. I'm super uncomfortable appointing someone as a guardian, particularly for anything beyond this case. We often may want authority to go deal with the bank and go, you deal with this case. And frankly, in this kind of circumstance, they need a guardian for everything.
A general
anyway.
guardian.
So they're going to need to go to probate court and get that done. And so I try to encourage them to do that right now. I'll appoint the person as their guardian for the purpose of the prosecuting this case for 60 days or something, and then I need to get that process started. Because again, they're going to need that for all sorts of other things. In this particular circumstance, I also want to know, do they have children? Does he have children? Who are the other people who are going to be interested in this? People who might come and say, hey, he's not.
Mary's not so good.
He's in California, or whatever. People who might have something else to say about this, they might show up.
It's hard because how do you know who those people are except for through Mary? And how do you give notice to all the proper people unless someone like the judge is asking? And I guess that's my question too for you, Judge. When do you need the state court to get involved? When do you require state court involvement as opposed to the bankruptcy court?
like Judge Bezier said.
So I think it depends, right? It depends. The Saladana case, which is on the screen now, lists the duties that a guardian ad litem can perform during a case. They can do everything. So if you don't feel like if there's no need for banking information, if there's no need for other things, I think under the case law, a guardian ad litem would work, and you wouldn't need a true guardian. So
Probate court has people who can go out and visit with them and do things that otherwise all we do is put them on stand and not testify.
Well, I guess that's the
No.
question. What evidence is needed, Judge, in order to, with your 1004.1 motion, you filed the case as a next friend, right? And that's all the next friend's really going to get you, right? The next friend is only really going to be able to file the case for you.
Right.
At that point, the court must appoint a guardian, is what the rule says. Must, right?
So just the way we talked about it, the next friend is a stopgap. That gets you
Right.
in the courthouse door, file the petition, then early in the case, file a motion to appoint Mary, whoever the appropriate person is, as the guardian for purposes of the case.
So under Georgia state law, the probate court doesn't even need medical testimony to determine someone's incapacity. There's a case, it's called In Re Cash. I don't think we have a slide on it, but if you're interested, it's 298 Georgia App 110 from 2009. And it says that you have to have clear and convincing evidence, but that can be from family members or alternative sources. It doesn't necessarily need to be a medical provider. So I think it's all very fact specific to your case and what is happening. But I don't think under Georgia law you need a medical testimony. So I think it depends on what you can get, right? If Mary says John has 3 adult children from a previous marriage, so maybe what you do is you get the 3 adult children's addresses and you notice them with the motion to appoint, right? Let's see what happens. Maybe they all show up and they say not so fast. And then you know that there's something going on. Mary hasn't been truthful with David, and the children hire Leon, and then we have a fight. That could happen. Or it could be the children say, no, Mary has good intentions, and maybe that would bolster the motion enough, and it's clear, you have clear and convincing evidence.
Or the court could appoint a third-party guardian, an
Absolutely.
attorney, for example, that's
Absolutely.
not interested, because you're right, they have.
So
Yeah, and we may want to go to the cases.
Yeah, we can talk about the next.
Julie has a question, I think. Right. And probably waive the beginning and the end so you don't have to do it again. Little practice pointer.
Yes,
John? Yeah, absolutely. Yeah. That's what we want to all do, right? Absolutely. We want to make Judge Beasley feel really good about this. No, for sure. A medical affidavit is always going to be better than no medical affidavit. But my point is, if you can't get it, you can find another way.
If Mary's on the up and up, a lot of people are used to doctor's notes. You know, everybody went to school with show up
Right.
doctor's notes. So, I mean, a lot of times these people will say, hey, I've got this and this from the doctor. Do you want it? And then so the discussion we had was, do you file that on the record? And the answer we came up with is probably not. But you show up in court, obviously, these medical records.
So, David, let's talk about the cases.
Yeah, and that happened in the Rivas case up there, and that's it's a 2023 case. It's recent. It does an excellent walkthrough of 1004.1. If you forget everything I said, if you read that case, it'll tell you what to do. And the facts in that case are very similar to our hypo. It was a joint case filed by the wife, and she signed as attorney in fact for her husband based on a valid power of attorney. The court found that the husband was incompetent, and again, it looked to state law that uses the word capacity. The court said the power of attorney wasn't good enough. It didn't rise to the level of a general guardian or a conservator. And the court said, based on the rule, I have to appoint a guardian ad litem. And just to be clear, the ad litem means only for the bankruptcy. Okay, it's not a general guardian. It's just a bankruptcy guardian. And in that case, they had a letter or an affidavit from a nurse practitioner to help support that determination. Then the Benson case is a Judge Bonifel case, and that tackles the issue of having multiple children. I think there were 4 children. Was that your case, Brandy? Yeah, there were 4 children that they were acting in I think good faith to help out their parent, but they clearly didn't know enough of what was going on. I think they didn't even know what ownership of the real estate she had. Oh, and more importantly, they didn't agree. And then the judge appointed one of our bankruptcy colleagues as the guardian ad litem. So you don't have to appoint the next friend. I think that's the presumption, maybe, but you don't have to.
Judge Sigler. I think that's exactly right, and that causes a big problem in those cases. So, but I think you're absolutely right about that. And then you really need to think about in a Chapter 7 case, the debtor might be able to do that and be able to get through a 7 without practicing law, right? They'll go to the 341, and that usually is the end of their practicing law involvement. But in a 13, probably not. I don't know. What do you think, Melissa?
No, I think you're right. And pro ses are always problematic for many reasons, but thank you for bringing that point up. Let's talk about, let's bring another wrinkle. Rule 9010, which is the authority to act personally or by an attorney, power of attorney. What is this rule getting at as opposed to 1004? How does it relate?
So I don't think Rule 9010, I know when we talked about this, does this give you an end around for Rule 1004.1? You know, can use a power of attorney? Because it says an attorney, in fact, can act on behalf of the debtor. In my opinion, it would swallow the rule, right? If a power of attorney was enough, well, then we don't need 1004.1. Then the judge brought up, well, what if you don't have an incompetent person, someone who's competent, so now Rule 1004 doesn't come in, but they're unavailable, they're incarcerated,
Military.
or active duty military. That made me second guess myself, as judges tend to do, or make me do. I did go looking. I found a case for an incarcerated debtor out of Florida, of course, and that court found that the father couldn't do it as a next friend, but it wasn't a power of attorney, so 9010 didn't come in. But it led me to a case in New York of the Tagliano, where it was a power of attorney. The mother wanted to file for an incarcerated child, and that court said no. Anyway, perhaps that's an answer. However, Colorado has a state law that says a power of attorney is a valid reason to file a bankruptcy. So maybe not. I still have a big problem with it, and this, I think, echoes what Judge Sigler was saying, that it strikes me as filing a bankruptcy for somebody else is going to be practicing law. And the rule says that's where you have to stop short. A licensed attorney can take any act for the debtor, but an attorney, in fact, it has to fall short of practicing law. And I think the decision of filing a bankruptcy for someone, that has to be, right? Okay, so
Yeah.
that's how, I don't think 90-10 lets you do an end
Yeah,
around.
I do think there's a split of authority around the country regarding this exact issue, but I think the split is derived from state law. Like you said, in Colorado, it's appropriate,
Yeah.
and then in Rivas, it's not appropriate. Under Missouri law, you can't do it. So I think that's the genesis of the split.
All right. Anything else on
On
incapacitated
yeah,
or
on part
incompetent?
one
Any
here.
questions? Oh, no. All right. Well,
Okay.
we're going to move on to our next section, which is about the dead debtor, the deceased debtor. All right. And all right. So hypothetical. A joint Chapter 13 case is filed and confirmed by John and Mary. Several months later, John passes away. Mary remains employed and intends to continue making plan payments, retain the home, and complete the Chapter 13 case to obtain a discharge. Given that John had minimal income but substantial joint debt, can the case proceed? What action should the attorney undertake? So, David, what do you do in this situation? What do you file with the court? How do you handle what rule is all of that?
Yeah. Well, first you got to get Mary in. That's step one, right? And there is a rule that we have. It's Rule 1016, and it says the court may dismiss or the court may permit the case to continue. We've got two mays in there. That's going to indicate a lot of discretion for the judge, and it means it's probably a fact-intensive case-by-case situation. I know for me, after talking with Mary, if the original analysis and objectives are the same and Mary can do it, then other than filing a suggestion of death, you may not need to do anything at all. If she still wants to save the home and pay the car and get a discharge, and she can afford it, then I think that's it.
And so the court's not going to know about the suggestion of death, correct?
Probably not.
Not unless there's a
somebody-
motion.
Right. So that's my question. When you see it, will you see it, Melissa?
Yeah, so I personally review those. I get the suggestions of death, and so I evaluate. Is it a joint case? If it's a joint case, is the debtor still the living debtor, surviving debtor, are they continuing to pay? And then my question's going to be, are there insurance proceeds? Ugh, I hate asking that. It's so uncomfortable. I have to email you, or I have my staff attorney email and say, hey, sorry your client died, but did they get any money? And then you have to ask your client that. But unfortunately, that's part of the estate. Yes. Are there probate issues? Is it feasible? Is it feasible for the plan to go forward? Do we need new schedules? Well, I mean, I sort of evaluate feasibility. Are they paying? I mean, I'm not looking to dismiss anybody's case if I don't have to. So, typically I let it ride if there's a joint debtor. If it's not a joint debtor, then I'm going to file a motion to dismiss under the rule. And then it'll come before the court. Occasionally we have a relative that pops up and wants to pay it off. I mean, there again, if people are getting paid and no one's complaining, I'm not going to make a fuss about that. But eventually you're going to have to deal with it as counsel because the debtor can't get a discharge if they're deceased, and then you don't have a client. So that's where it gets thorny. Can you file anything? What can you file, and how do you handle that, I guess?
That is where it gets thorny. And I know we talked about, do you need to sever the case? I hate severing cases.
We all hate severed cases.
It's messy. But like we have here, I think letting the case continue makes the most sense when it's a joint case and one spouse passes away, because you still have a debtor, and she can afford it. When one debtor passes away, by severing the case, are you acting for them without authority? Now, Mary, I suppose what would happen is Mary could maybe sever her case, and then John's case has a natural death and dismissal. Maybe you're not acting for a client that doesn't exist anymore. But I think what's more likely, it comes up with a plan modification or an MTD filed by the trustee or maybe an aggressive creditor. I don't know if we want to put the cases up. Is that the next slide?
Sure.
Okay.
While you're doing that, I do want to say this. You know, the federal rules, Rule 7, Rule 25 of the Federal Rules of Civil Procedure, and Rule 25 of the Georgia Civil Practice Act have this provision for filing a suggestion of death. And if the suggestion of death is filed and no action is taken within 90 days, then the case can abate and go away. But it's interesting to me that, so if you look at Federal Rule of Bankruptcy Procedure 7025, it says that Federal Rule of Civil Procedure applies in adversary procedure. So if you've got an adversary, you have really an affirmative duty to file the suggestion of death. But interestingly, there's not a provision in the bankruptcy rules themselves about filing the suggestion of death. But in our discussions, it's like, well, the judge is going to think it's really odd, 2 years into a 13, if it comes to everybody's attention, the debtor passed away. So, it was obvious, as David said, we all think you should file a suggestion of death. But it's not in the rules, except what I did figure out this morning. I looked just curiously at 9014, and it does adopt Federal Rule of Bankruptcy Procedure 7025 into contested matters. So if there is a contested matter, you do have that. So if you don't file the suggestion of death, you can have some of those abatement issues where the cause of action goes away if you don't file the suggestion of death. Anyway, sorry for the diversion.
One thing I would mention too is please do not file the death certificate on the docket. That happens. It is the most invasive document.
happens a lot.
Ever. It does happen a lot. It tells
And it's not
everything
redacted.
about the person and they file them unredacted. It has horrifying details about your client, and that should not be shared. Judge.
So, if you have a case to proceed with so you ought to proceed, it must proceed and be concluded in the same manner as though the death of the accomplice has not occurred. What do you do about the federated case that something is supposed to get?
Motion to waive?
Theoretically, that's still required.
I think you got to file a motion to waive. That's what we do.
Right, but I think Judge Beze's point is if you're continuing as though the death or incompetency hasn't occurred and you file a motion to waive based on the death, then it's not as the case was going to proceed otherwise. So, yeah, there's a disconnect there.
Yeah, it's a conundrum.
It is, but one that we can probably all just ignore, right? I'm comfortable with that if you are, Judge.
I think it depends, right? Like, what if you have the 3 children that have now changed their minds and they're hopping mad about the whole case and they're making other allegations? They may argue that. Then you would have to really decide, what does that mean? Yeah. I don't know. We did not look at as though the death or incompetency had not occurred.
I will say that practice pointer, have your client do the financial management class as soon as possible after confirmation.
Good,
Yeah.
Well, you need the 1328.
Family's
Yes.
going to want the discharge, right? Children are going to want it. Everybody wants it.
That's right.
They want to pay off the car. And these facts are why, it's a fact-intensive inquiry, and that's where the cases come up. And when I looked at these, they vary broadly, and that, I think, comes down to the judge and maybe the facts that are going on. The one in the middle, the Price case, I think this is best case scenario to continue the case. It's a lot like our fact pattern here. Mr. Price passed away. A creditor filed a motion to dismiss. The court found that Mrs. Price, she could fund the plan. She owned the home that was involved. And it was in everyone's best interest to let her continue. And like I said, that highlights a case where it probably makes the most sense to continue it. A bit further out there, this was maybe an outlier, the Thomas case. It had an unconfirmed plan. The debtor passed away before confirming, and her daughter stepped in. There was a home involved, and the daughter wanted to save the home. The bank objected and moved to dismiss, and maybe surprisingly, the court let this one continue. The court relied heavily on discretion under 1016. And one other noteworthy thing, I don't know if you all have had this happen, in going over what the bank wanted. The bank filed the motion. Presumably, they thought it was in their best interest to dismiss the case, and the court said no. I think it's in your best interest to let it continue. And I wonder how that would feel Judge, telling a party, I know better than you do what's good for you.
Wasn't Thomas, were the facts that I think this was the case where there were 3 previous cases filed, and the testimony, or there was an affidavit that suggested that every time Ms. Thomas filed a case, the lender said, oh, get out of bankruptcy, we'll modify the loan. And so that happened 3 times. The loan was never modified. So I wonder if that weighed against the lender and for the debtor at the conclusion of the decision.
And is there sort of like a continuum of the further down the line the 13 is, the more likely that it can be?
Well, right, because there's less bad things that can happen and changes that occur, right? But the problem really does come up to is what happens if you need a modification? That's a problem.
What about hardship discharge? Can you get a hardship discharge for a dead debtor? And as counsel, you're filing a motion, but you don't have a client. So,
Well, and that goes
it's
back.
a hardship. Death is definitely a hardship.
Yeah. Well, that goes back to the problem. Can you act for a client that doesn't exist anymore? And I want to, maybe I'm too cavalier here, but I want to push back on that. I mean, I know when the client first came in what they wanted. And if that hasn't changed, I don't think I need ever renewing authority to do what they originally paid and wanted me to do, which was to get them a discharge. And the cases out there on these hardship discharge issues with a dead debtor say death is a valid, perhaps the most valid reason to grant a hardship discharge. So I thought that was interesting. And I did find a case, it's not up there, but, when we talked the other day, it prompted me to look. It is In re Shorter, 544-BR-654. A creditor objected to an attorney filing a hardship discharge for a dead debtor. And the court found that in any event, I'm going to say that the wife, she wasn't a debtor, but that she had standing to authorize the attorney to file that motion. So I thought that was interesting. Then finally, the Pfeiffer case, that one got dismissed. It was a debtor that passed away before confirming a plan. His probate estate came in and wanted the case to continue. Without a confirmed plan, and then there were vague future events like selling artwork to fund the plan. The court said no, that's a bridge too far. I'm going to dismiss this case.
What about the fact that Mary didn't own the house? That was the main reason for filing. And now she didn't own the house. He's gone. Can she continue in the case?
It's one of those, it depends. I think if she can fund it, and maybe she's the one that's going to get the house if there's no kids. I don't know. But these are the things you'd have to kind of drill down and see what you feel comfortable with.
I mean, I would say that I'm going to assume that she's a successor in interest, and the regulations require the mortgage servicers to deal with successors in interest. So I think you're probably safe with that. But it's all fact specific. All right. Anything else on?
Do we have any questions
dead
on
debtors? Any questions?
Deceased debtors?
Yes, Anna.
Did anyone object?
That always helps.
And that's the best outcome for everybody. So hopefully everybody would agree on that.
All right. Anything else? All right. We're going to move to our next topic, which is the divorcing debtor. Yay.
Are you married?
Yeah. It's always fun. Well, it's not Mary because we're going to pretend like John's competent. So prior to the completion of the plan, John has miraculously recovered from his stroke, has a new lease on life, decides he no longer loves Mary, and plans to divorce her. He now seeks financial separation and question his ongoing liability for the joint debts covered under the plan. What should debtors' counsel do? Leon. And I'll bet everybody, how many times do you see divorce debtors? Once a week, once a month, all the time, right?
Or a lot of times they come into your office and say, what happens if we get divorced?
Which post confirmation might be a little better than pre confirmation
At any
or pre
rate,
petition.
I mean, this is everybody's favorite topic, right? The intersection of divorce law and bankruptcy. What we're going to talk about at the beginning, fundamentally, 109E says that two spouses can file a joint petition if one of the spouses is eligible for 13, the other one can be in a 13, even, for example, if they don't have income, recurring income. And then 302A permits joint administration. 302B allows consolidation. And Federal Rule of Bankruptcy Procedure 1015 allows a joint administration of spouse cases. But underlying all of these rules is what we all know is that it's two separate estates. I mean, it's two separate individuals. And just because they file a joint case does not constitute substantive consolidation of the two bankruptcy cases. So if Mary comes into the office and you have been, John comes into the office having recovered, hopefully you or David went out to meet him when he was in the sick bed or otherwise, sitting there incompetent. So now he comes to David and says, hey, I'm feeling a lot better now and I don't want to be married to David. It really, from an academic and real world point of view, I mean, it puts the lawyer in a potentially conflicted situation because John wants to, separate financially from Mary. And at this point, we're presuming, I think, that there's a confirmed Chapter 13 plan. So, we want to sort of unpack the rules of professional conduct. And we start with 1.7. And it says, a lawyer shall not represent or continue to represent a client if there's a significant risk that the lawyer's duties to another client, a former client, or a third person will materially and adversely affect the representation of the client. So then, if you look at Part B of 1.7, it's a conflict waiver provision. The lawyer may represent the client nonetheless if each affected client or his former client gives informed consent in writing. This informed consent is not allowed in certain circumstances. That's what we this mic does work after all. So it's what we colloquially refer to as a conflict waiver. So what under 1.7b, which we have up on the screen, how do you obtain an effective conflict waiver? Well, it requires 1, consultation with the lawyer, and 2, having received in writing reasonable and adequate information about the material risk and reasonable available alternatives to the representation. And 3, after having been given the opportunity to consult with independent counsel. So, this is where the practicalities of the situation reveal themselves. Is this an amicable divorce? And it does happen, where John and Mary both come into your office and say, we're splitting, but we want to try to manage our finances and manage this case out as best we can. Or is this a highly contested divorce in which John and Mary hope to never be in the same room together again? In which case they certainly have no intention of appearing in your office for some sort of joint conference about a conflict waiver. So,
or to be stuck together for the next 3
for
years
the
to complete the
length
plan.
of the plan. And if you look at this hypothetical, it's, John's, the way it's written in the new revision of it, John's sort of, revealing that he's not really interested in supporting Mary for the life of the plan. So, if you look at 1.7c, which is the next slide, what's a non-waivable conflict? When can John and Mary, even if they both want to sign a conflict waiver, when is that not allowed? Well, 1, if it's prohibited by law or rules. 2, it includes the assertion of a claim by one client against another, represented by the lawyer in the same or substantially related proceeding. So, I think it's obvious that the bankruptcy lawyer here does not plan on and is not representing either John or Mary in a divorce case. That's obviously a non-waivable conflict. You can't represent them both. So the third example of a non-waivable conflict is where it involves circumstances rendering it reasonably unlikely that the lawyer will be able to provide adequate representation. So you query, do John and Mary have claims against each other in the bankruptcy court? Okay. The fact is, if they're going to go to divorce court, they're going to be having an equitable division of their property. That's required in Georgia in order to obtain a final decree of divorce. You have to have an equitable division. But if we could skip over to I want to talk about the automatic stay. So let's go to 362B, given the time. One thing to think about is John either comes to the debtor's attorney's office and said, I want to get a divorce, or tells the lawyer, perhaps in a different circumstance, I have filed for divorce. And so, under 362B, there are certain domestic relations actions which do not violate the automatic stay. There are exceptions to the automatic stay, and that is, as shown on the slide, an action to establish or modify domestic support obligations, or 2, for the dissolution of a marriage. So, just a divorce action in and of itself is accepted from the automatic stay, but then you look at the parenthetical and it says that the exception to the automatic stay does not apply, except to the extent that such proceeding seeks to determine the division of estate property. Now, in most cases, that's going to be the case. So
especially if they're in a bankruptcy, right? Because obviously,
yeah, that's right. So what I'm suggesting to you is, John or Mary may or not have a divorce lawyer. It could be even tougher if they're both proceeding pro se. But I think that it would be incumbent upon the debtor's lawyer, or perhaps one of the spouse's state court lawyers or divorce lawyers, to seek modification of the automatic stay to allow the divorce action to proceed, if there's going to be an equitable division. And then, what does the bankruptcy lawyer do? Maybe the bankruptcy lawyer files it himself, presuming the clients are in agreement on that. You just file a motion and ask for the court to permit, the bankruptcy judge to permit the divorce court to do that. Now, let's skip one forward one slide to N. Ray Johnson. This is a bankruptcy. This is Judge Gasparini out of 2023 decision out of South Carolina. An equitable distribution determination by the family court would necessarily involve property of the bankruptcy estate. That's what we've been saying, right? And there's a site if you need one for that proposition. So one more slide over, we have the 11th Circuit opining on this, just for, folks that really want some high authority. And here the 11th Circuit said, limited to its proper role, the bankruptcy court will not duplicate the functions of state domestic relations courts, and its rulings will impinge on state domestic relations issues in the most limited manner possible. Now, I can't say that I've really needed the 11th Circuit authority to convince a bankruptcy judge to stay out of a divorce case. Typically, the judges are more than willing to allow the superior courts of our state to adjudicate the equitable division issue. But I do think that that's what really Williford is one reason it's interesting is in that case the divorce case had proceeded in violation of the automatic stay, and Mr. Williford had received in the equitable division 0 of the marital assets. Mrs. Williford had received all of the marital assets. Well, you can imagine after that ruling that Mr. Williford suddenly realized that, hey, this divorce decree is void because it violated the automatic stay. So he seeks to, in that case, dissolve the confirmation order on the fact that it was void. The bankruptcy judge found that the creditors had not been prejudiced, that Mr. Williford's sour grapes were duly deserved and annulled the automatic stay, which, as we know from an 11th Circuit case recently, is fully available to the bankruptcy judge. So, that's an example of how it could happen. But, it could happen. The facts in that case were even a little bit more egregious because the 11th Circuit itself said that the debtor's lawyers were aware that the divorce case was pending at the time of the bankruptcy, and it appeared to be there had been, I guess one reading of the case is there had been a gaming of the system, and you really have to wonder about the decision made in that case to proceed in that manner. So another issue to keep in mind with respect to divorce cases is on the next slide, the attorney-client privilege in a joint representation case. Again, you have two clients, and while they are a marital unit, they are one economic engine. But if one of them wants to part ways and seeks a divorce, what does that do to the privilege? And the joint privilege is a tricky thing. So it's something to keep in mind in these circumstances. The first question is, there's the federal common law on attorney-client privilege, and there's the Georgia law on attorney-client privilege. So what law applies? And here there's a Middle District of Florida bankruptcy case, which I think sets forth the proper rule, which is federal common law and privilege governs where the rule of decision is made under federal law, and if the rule of decision in the case is under state law, then the state law privilege applies. So, obviously, if this is a bankruptcy case, that's federal law. So with respect to issues arising in the bankruptcy case, then, the court would apply the federal law of the federal law of privilege. So what's the difference between the two? Let's go to the next slide. Here, there's a Third Circuit case. The caveat of joint client privilege is that it protects communications from compelled disclosure to parties outside of the joint representation. When one former client sues another, the default rule is that all communications made in the course of the joint representation are discoverable. Okay. If you look at the Peterson versus Bumwell decision out of Georgia, it's the same rule. So if two people are sharing a privilege, they've got an issue if one of them has the ability to waive the privilege, which they do. If you're the lawyer and you're representing joint clients, and you need to understand that if John later seeks a divorce from Mary, all of the communications you've had with either one of them are discoverable. So, caveat.
Let's talk about severance a little bit. But before we do that, can I ask the judge? I'm sorry. Yes, Nancy.
I agree.
It's narrow. They're narrow circumstances. David, I think you have a take on that.
Maybe I'm too cavalier here, but when this happens to me, and the joke is that every Chapter 13 has a divorce or a car wreck, right?
Or both.
Yeah, or both. And a friend of ours up in Rome, he had two clients actually hit each other. He got two calls on the same day and said, "Well, this sounds familiar."
And then they got married.
Each other. Anyway, if they tell me, and this is maybe the amicable divorce situation, I tell them if you can agree how you divvy up the plan payment, because that's usually a big sticking point, I'll go with whatever you tell me. If you want it 50-50 or 80-20, I'll also tell them, if you want me to give my unbiased opinion on what I think is a fair split, maybe one spouse makes more than the other, or one spouse is keeping the car, I'll give them what I think is a fair split. But if they can't agree, I think Nancy's right that you've got probably an unwaivable conflict.
Particularly pre-confirmation. I mean, if you're 4 years into a plan, maybe.
Well,
Then now you're over the edge. Then,
Yeah.
I
At
mean,
that point, you'd have to go.
we were doing some of the academic breakdown, and now we're talking about what happens in real life in the typical Chapter 13. In many of these Chapter 13s, if you're in year 4, it's probably in the best interest of both of them to complete that plan and get their discharge. But if you're in year 1 and it's in the best interest of Mary to, go 7 and get a discharge in 90 days instead of waiting 4 more years for a discharge, and it's in the interest of John to, keep the house that he owns and cure that mortgage arrearage, over the life of the plan, then you've got one client that's better off in a 7 and one client that's better off in a 13. And that's why Melissa was saying we need to talk about severance next, and Nancy's question was right on the money and leading us there. But, I think, and by the way, for the Chapter 11 folks out there, we're not talking about disinterestedness. If you have 2 joint 11 debtors, it's a totally different. There's plenty of case law out there that would tell you, beyond this point, there'll be dragons. I mean, that's dangerous. But in a 13, you don't have 327A, so you don't have a disinterested standard. You go back to the bar rules. Is this a waivable conflict? And if they have claims against each other in the case, that's not waivable. So at that point, Nancy, prophesized, can you represent either one of them? And the answer is...
What if they don't know that they have claims against each other yet?
Well, I think you have a duty as a lawyer to vet that, because what's going to happen is the way I see this is the kind of you don't have the conversation with Mary in year 1 of the plan that says, hey, by the way, you've got a right to convert to 7 right now. 7 looks good, and then. So 4.5 years later, she gets her Chapter 13 discharge, or she goes to see somebody, and they say, well, you could have done 7 a long time ago. Mary's going to be pretty unhappy with you. So, I think that the lawyer has a duty to independently, at that point, you're representing 2 people with potentially, and we're assuming at this point in the hypothesis that they have divergent interest and want to go separate ways financially. I think you've got a duty to analyze it for both of them. And, if they aren't willing to waive the conflict, then, you have to consider at a minimum withdrawing from representing one of them, or in this case, you're not going to make Judge Richie Craig happy if you just withdraw and leave a Chapter 13 debtor unrepresented. So you're going to have to go get a friend, somebody in this room, and say, hey, I've got a Chapter 13 debtor that needs representation because they're getting a divorce, and I've got a potential conflict situation, and so you might need to bring in another lawyer to represent one of them. And so that leaves you, let's say the lawyer chooses, not that it's the lawyer's choice, but so this is a bad way of phrasing it, but if the lawyer ends up with John, the existing Chapter 13 debtor's attorney ends up with John, and Mary refuses to waive the conflict for John to, for the lawyer to continue representing John, that's fraught with risk, and that's why I sort of went through this attorney-client privilege scenario before getting to the real meat of it, because, you got potentially divorce lawyers out there that can subpoena your records or put you on the stand and ask you about all the marital assets and all the discussions you had about the case, how it went. So anyhow.
So Leon, let's talk about the practical implications of what's going to happen, which is that you're going to sever the cases, probably, right? The cases are going to need to be severed.
Right. So
what happens then? How do you?
So there's some cases out there. If we can go to, okay, you're ahead of me, as you knew. So there is a case from the Southern District of New York. This is a 2025 case. And it goes back to the rules I mentioned at the beginning, which is 302 permits the joint petitions. And 302 does not expressly address severance of cases, but we all do it. Everybody's aware of it, and it happens. And here there's a good quote, if you needed that, which says the court has the inherent power to sever the two cases.
If one debtor wants to dismiss, though, you can voluntarily dismiss them, right, without severing.
Yeah.
That debtor goes away, then you can continue with one, right?
That's right.
That's one.
So I think that's right. So Mary, you have a conversation with Mary, and you explain to her rights, and that includes voluntary dismissal. I think, as long as John's not going to, as long as he, I think, consents to that, then you're okay with that dismissal. If he refused to consent to you taking that action on behalf of Mary, that's more problematic.
I guess another scenario would be that they both want to continue in their own 13, so then you got to file a motion to sever. And within that motion, you've got to determine which claims are going to be addressed in each case, right? So you got to do the work of going through and figuring that out and setting that out in the plan. You got to address any fees to be paid. Who's paying what?
Yeah, if you call up your attorney friend and you want to hand off this great case to them, right? They're going to want to be paid for it.
Probably.
It's got to be a really good friend. And you'll owe them one.
And I want to point out, you don't have to have a divorce to have a conflict. Couples fight all the time. Sure. We have cases that they're happily married, but I'm not paying another dime into this bankruptcy plan. Stop my EDO. These issues pop up there too.
It could be that one of the debtors needs to convert. So do you have to file a motion to sever, or can you just convert that one case? I think you do have to still file a motion to sever, right? Because you got to have a new case number.
That's right.
A new actual case.
And let's go to the next slide just for kicks. The Seligman. In this case, there's a pretty good quote that says, if one spouse has, the court obviously allowed the severance of the cases. It was a 13 and allowed one of the debtors to convert. And here, there was some opposition to that, and the court, I think, properly said, if one spouse has the ability to block severance by withholding consent, the threat of one party holding the other's discharge hostage could be used offensively in a divorce proceeding. So to Melissa's question and point, I don't think one of the spouses can block the other spouse from severing and converting.
They just might need a new lawyer.
They just might need a new lawyer, as we were talking about. And I think in under the facts of that, obviously you do.
And any questions about
anything else on divorce? We could go on and on about divorce, right?
Send them all to Superior Court.
Yeah,
I do have one more question, Judge. What role, if any, does the bankruptcy court play in determining who gets what assets?
In a severance or in a divorce?
At all. Ever.
Well, I am not thinking about divorce here.
I think that's the answer.
I'm sending them across the street or wherever they need to go to Superior Court. I don't really want any part of it.
Do you want to know ahead of time if they're going to do you just grant the stay and then whatever happens, or do you want to know how it's going to get?
No, usually I leave all that to someone else much more qualified to listen to domestic problems. I've got kind of a case in progress right now where I shouldn't talk too much about it, but there's divorce and there's property and there's an allegation that they're seeking direction from the Superior Court to preempt the bankruptcy court. So weird things can happen from time to time, but 99.9% of the times I don't want to get involved with divorce or divorce court or separations. So I want them to go see a Superior Court judge.
You're happy for
I
them.
don't
So
have
would
the-
you?
I don't have the authority to speak on behalf of any of our judges, but I would be absolutely shocked if that was not a pretty uniform.
I think that's a
belief.
fairly uniform consensus. Judge Muzier, do you agree?
Right.
Gave all the property to the wife and all the rest of it.
Now let's convert and
But you don't want to hear a divorce action, do you? Okay.
Eric, I think you.
I think that
It could be, and you can always caveat in the order, go back and do this, but come back and make a report. I mean, there are baby step processes that you can build into orders if you feel you need to, or if the parties decide this is what we need to do.
All right, we got 2 more D's to cover. Let's see if we can do it. These are a little quicker.
yeah.
All right, the next one, the disappearing
And by the way,
debtor.
thank you to Melissa for the alliteration.
Yeah.
Yes, that was me. You can blame me for that. But all right, so new development. Forget about the divorce. John and Mary are still together, but John died. So after confirmation, Mary stops all communication with counsel, stops making plan payments, moves without providing notice. That never happens, right? And becomes unreachable. Debtor's counsel becomes aware of John's death. The Chapter 13 trustee moves to dismiss. What steps can or should debtor's counsel pursue? David, what do you do?
Have you all had this happen where a client, ghosts you? I think everyone has, right? Oftentimes something's going wrong in the case, so it's maybe not that big of a deal. Hey, it's doomed for dismissal, and you announce no opposition. My client doesn't oppose it, or no basis to oppose, I should say. I try not to take it personally when it happens. It's frustrating when it's something small. You need a tax return, and the case is otherwise in good shape, and your client is not returning your phone calls. But usually, something's not working. Anyway, the bar rules require that you communicate with your client. 1.4. So I think you need to try. And in terms of what to do, I think with the fact pattern here, the trustee would actually move to convert, right? And that is that situation worries me when there's a conversion and there's no client contacting you. Are you going to let it convert and have that house go away when they told you at the beginning that the most important thing is keeping my house? One of the best ways is to avoid this problem from the beginning, which comes down to intake. I can tell you, in addition to asking for multiple ways to get in touch with the client, we, in our intake, ask for 2 other people who should always know how to get in touch with you. Usually a family member, friend, maybe a neighbor. And it saved me in a case where it came up, the car lender had filed a motion about insurance money they had received, and there was a lot to be left over after the payoff, and they wanted to send that money to the trustee. I looked in the case, and the client hadn't been paying. We tried to contact her, and finally we got through to a daughter and found out that she had been deported to Guatemala. She had been here for 35 years. Hard to believe. But anyway, through the daughter, we were able to get in touch with her and decided to dismiss the case and have the extra money would flow to her. We didn't think any creditors were going to be chasing her down in Guatemala. But yeah, having that extra contact is what really saved the problem of what do you do. I still think it would be okay to dismiss that. I think you have a duty to do something to just say, well, I can't act, I can't contact my client. There is some cover. If you're worried about, am I allowed to do this? There's cover in Bar Rule 1.4 in the comments. It says you need to communicate prior to acting for your client, but if there's an emergency, you can use your judgment to act in that case. And of course, we've got Rule 9010 that says the attorney can act for the debtor.
So I wanted to say one thing about this, and that's about the disappearing debtor and the money. Okay, we have so much money in the trustee's office that we can't find your debtors for. A a lot of times it's the 2-cent check or the 4-cent check. And I know immediately they don't feel like depositing that. We still try. We beg them. We send them a letter. Please use your mobile deposit app. I totally understand that because I'm not going to the bank for a 2-cent check either, but now none of us have to, right? It takes 5 seconds. But I love this idea that David had. Get their mama's phone number, okay? Mama's number never changes.
Yeah.
Have it in your file. I mean, I think we should amend the voluntary petition. We might need to suggest that, Nancy, in the rules committee, if we could have like a next friend contact somewhere on the voluntary petition so that we can reach out to them. I think that's a fantastic idea.
Question would go like, well, who's the most responsible person that you know? And give them that phone.
Right.
You might have to swear to
Yeah.
secrecy
I think
until
you need to be
they're
careful
gone and
what-
they disappear.
They'll tell mama. Okay.
And some people bring their family members in.
That's true. But just so you know, just in our registry alone, our court registry, there's over $11.5 million. And that money just sits there forever and ever. I wish there was a rule that allowed us to do something if it's less than $15 to do something else with it. But unfortunately, there's not. And so that money just goes. We do research. We try everything. Mandy, my staff attorney, should be a private investigator. She's really good at finding out stuff about your clients if you don't know.
And there's some online sources like People Search. A lot of law firms have, People Finder technology, so use that.
Yeah, like Lexis is accurate. But even when we get in touch with them, if they've moved, we still have to get you to file a change of address, unfortunately, because I can't just send money randomly to another address. So we have to make sure it's the right person. So did you have anything to say about that? Vania? Oh, no,
She had to leave.
She had to leave.
So
Okay,
I would say the motions for unclaimed funds, there are a lot of rules that go with that. There's a big checklist of things to be sure that you include all of that. I don't see a lot of attorneys filing motions for unclaimed funds. Mostly it's the claims finders or whatever they call them for fees. But gladly, I mean, if they file it and they have all the documents, I grant them routinely. I don't really have problems with those. If it's done properly.
And then one more thing we want to talk about. What if Mary shows back up, but she's mad at you and she doesn't want you to represent her anymore? She has some friend that she now decided. I'm going to go back to withdrawal. We have a local rule in terms of withdrawal of counsel. Just make sure you reference it. Everyone knows it. It's Bankruptcy Rule 9010-5. You have to send a 14-day letter to your client. I'm sure everybody knows this.
So I would just say the rule is pretty easy to read. The one thing that's a little odd about it, it's an old rule. So it requires service by mail or personal. So don't get caught in an email situation and then have someone say you didn't follow the rule and you got to start over. So just mail the letter and then include that with your motion. Yes, there are 214 days.
And you have to file a motion.
Unless you get consent.
Yes.
Unless the debtor consents. And then if the consent happens, make sure that that's included and then the order can be signed immediately.
That's right. It's good to address fees though. If as the 13 trustee, the plan says for us to pay certain fees, we need to know, do we still pay fees? Because technically you probably earned that fee already. So if the order can be clear about direction of fees. Same thing if there's substitution of counsel. If you can, in the same document, if another lawyer's coming in that same order, tell us who's getting paid what when, that is very helpful. All right, and then quickly, we do have one more D, which is the disagreeable debtor. We don't have any of those, do we? All right, so Mary begins conducting her own research online and determines that she can independently draft pleadings and manage any required appeals using AI without your assistance. How should debtor attorney proceed, and what action should the judge take? We all know this is a hot topic. It's happening. AI really does get pretty it's pretty good. It's getting better every day. It's hallucinating a little bit less, but it still is doing that. But it can definitely help with basic drafting, which I know the court is seeing. I guess maybe it makes the illegible handwriting easier to read, but it also makes it more problematic in other ways.
So the pleadings are easier to read, but sometimes they make less sense because you can't tell what the person really wants.
Yes,
It's
or they're
really- it
making
looks
more
pre-
colorable
It
legal
looks
claims.
pretty. There's like numbers and subparagraphs, and it's beautiful, but it doesn't really work.
Yeah, I got a writ for certiorari. I think the court probably did this week too because it was filed against all of us this week, drafted by a pro se debtor. It's fantastic. Can't wait for that. So Leon, what should you do?
So the hypothetical at this point is if you're representing a client and they're using AI to outthink you, I think what you do is you explain to the client that they hired you for a reason. That was your knowledge. They hired you for your advice. You explain that AI is a great thing, but it's not capable of providing necessarily the accurate advice that in a convoluted bankruptcy case. And so you request the client to follow your advice. And in cases, we've all seen it where a represented debtor perhaps files a pro se pleading even while they have a lawyer. So at that point, if you're the lawyer in the case, you try to convince the client to withdraw it. If the client persists on a course of action which they believe is the right one because AI tells them it's the right thing to do, and that's a frivolous course of action, then I think the lawyer, and this is not something the judges like. I mean, you try to withdraw from cases as seldom as you can. When you take a case, you try to take it for the duration. But if you have a client, the way I look at it is the lawyer's the quarterback and is on the field and calling the play and throwing the ball downfield. And if the client doesn't want to allow the lawyer to quarterback the situation, that puts the lawyer in a difficult position, especially if it is a frivolous position, which could subject the lawyer to Rule 11 type sanctions at worst, or even not quite so bad, just advancing a position that has no merit. In that case, I think you have to withdraw if you've given it your all. And we've talked a little about how to withdraw, and as I think Judge Bassier mentioned, it's 28 days. And then assume you seek to withdraw, and this disagreeable debtor is so disagreeable they don't want you to withdraw, right? So let's assume you've got a contested withdrawal hearing. You send the notices out. They object to your withdrawal, and you show up in court. All right, so then what do you do? Well, it's Rule 1.6a, and we all know it. A lawyer shall maintain in confidence all information gained in the professional relationship with the client. So that's before and after you're the lawyer. I mean, so just even after you withdrawn, or even after your relationship is mutually terminated, everything that you learn as a lawyer is confidential information, right? So you show up at the at the withdrawal hearing in front of the judge, and you are bound by 1.6. You're not supposed to divulge attorney-client privilege information, and you want to do that to the least amount that you can. But there is 1.6b1, okay, and it says a lawyer may reveal information covered by paragraph 1, that's attorney-client privilege information, to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. Okay, so you look at comment 6 to Rule 1.6, and it says, the disclosure of the privileged information should be no greater than the lawyer believes is necessary to vindicate the lawyer. So I'll just make this really legal. You're dancing on the head of a pin, okay, and you're trying to say as little as you can, and it could be as simple as, we have a difference of opinion, Your Honor, over the course of this case and over the actions that need to be taken. Now, if the client opens the door and attacks the lawyer, then the lawyer, I think, does have a safe harbor in 1.6b1 that said the lawyer can divulge kind of confidential information to the extent necessary to vindicate the lawyer. But you really try to avoid any of that.
Yeah, I would say that I see this a lot, is that client shows up in court and starts bad-mouthing debtor's counsel in front of the court, and attorneys sometimes go too far in what they say about their client. What do you expect, Judge? I mean, you know, right? I mean, you.
So I think Leon is absolutely right. I think you go as far as you can go without divulging privileged and confidential information. And when it's happened in my courtroom, I try to tell the debtor, I understand you've got this problem, but we all don't need to know all the specifics of the problem because it's not public information. You do have confidential information with your attorney. And sometimes hearing those words come from a judge, they go, oh, okay. And something snaps and they click and they hear it. Sometimes it doesn't help. But I can tell, I guess I've been doing this long enough that I know most of the lawyers that are in the courtroom. I can tell from their body language and from what they're not saying that this has become an irretrievably broken situation and they need to get out. And I can tell. So I don't need a lot of words from the lawyer. I don't need them to bow up and be quarterback times 4. I just need for them to diffuse the situation, and then you can withdraw and we deal with it that way.
I love it, Judge, because you came back. I did make a note here at the last minute. Irreconcilable differences till you go back to the divorcing debtors.
Yeah. Sorry. I hate divorce, but yes.
Those are magic words. If we say, Your Honor, I'm sorry, we have irreconcilable differences, I would like to withdraw. Please let me out.
Right, and there are times that I want to know, but I don't need to know. Nobody really needs to know. I mean, I have to take you at your word, right? We've had a problem come up. It's a tragic problem. We're not going to get beyond it. They want something and I want something else, and I think this is better and they don't. We need to part ways. You don't even have to go into that detail. So, but a lot of times too, debtors just want to be heard, right? They want to tell their story, and if they have an audience, sometimes they just say too much.
But it's probably not appropriate to put your client on the stand and start cross-examining them.
No, you don't need to go that far.
You're trying to avoid throwing them under the bus as best you can.
And still protecting them, right? Because
Right.
what if you know something that the court really doesn't need to know under those circumstances and it's going to harm the debtor? Then you're really not doing no harm, you're doing harm to them, even though they're no longer they're still your client at that point, but they won't be soon.
All right. Anything else on that?
We're good.
No. I will say one last thing, and this is that we were at the Atlanta Bar Year in Review a couple weeks ago, and Beth Ann Harrell talked a lot about AI. But if you need any sort of AI source, there is this French professor, Damien Charlatan, who is...
That's excellent, Melissa. I'm impressed.
That's my French major.
Yeah. You
He
were.
has apparently every case in the United States for some
I actually
reason.
played around on that website. And the cool thing about it is, the one more thing, I will give a plug to Southeastern Bankruptcy Law Institute, SBLI, is going to have several sessions coming up on AI. And as I think we said at the beginning of this, it really, to me, I don't know how long everybody else has been seeing it, but for past 6 to 9 months, it's really been an uptick. But this French professor's site is cool because he's trying to do a compilation of all the AI cases, and it shows them, and you can click on it, and it gives you the case, so you don't have to go find it. But there's one of the SBLI presenters is a law professor, and they've tried to assemble all the bankruptcy cases concerning AI. So that'll be worthwhile.
Great. Any other questions? No. All right. Well, thanks for listening. I know it was long.
Thank you.